Ron was the plaintiff's lawyer in the Cardi B case, and we were pending an order to show cause for sanctions, and his response was wild, and he has responded again. During the Cardi B case, I was befuddled by his behavior, and so I had Googled real quick to see when he had passed the bar. Turns out a year before I did, which means he's been a lawyer over 20 years. In that quick noodly search, it came up that a fairly significant civil case had been declared a mistrial by a judge that I actually know because Ron, and counsel for the other side got into a physical altercation in the hallway, and the observers said that Ron started it, grabbed the other attorney and like spun him around, and his glasses fell off, and Ron stepped on his glasses in the hallway. And there was so much of a kerfuffle that the judge declared the entire civil trial a mistrial. That case is getting ready to go back to trial next year. It hasn't gone back to trial yet. And so there were things that happened in the Cardi B case that led me to question this attorney. At the end of the Cardi B case, Cardi B's lawyers said, but we are asking for an order to show cause regarding sanctions because this attorney violated numerous court orders. We had been waiting to see what happened because at the last hearing, it was just a status hearing and Cardi B's attorney was not there. It was, has the final judgment been filed? Yes, it has. Then the judge issued an order. So this was October 20th. Notice how the court crossed out proposed. So this is no longer a proposed order. So on the side, you're going to see electronically received. That's when the original was filed. The court just adopted the proposed order, crossed out proposed, signed, stamped. This is the order now. So the judge has issued an order to show cause hearing. To plaintiff's counsel, Ron, defendant Cardi B, having presented to this court sufficient grounds to initiate a contempt proceeding, you are ordered to appear on December 5th at 10 a.m. in Department T. Not a joke, it's Department T. Show cause why you should not be 1, held in contempt or otherwise sanctioned, or both, for violating this court's July 30th, 2025 order precluding evidence or reference to purported gang affiliation and excluding Dr. Alex Avila as a witness. 2, held in contempt or otherwise sanctioned, or both, for violating the court's September 2nd, 2025 order in open court not to reference in his closing argument facts not in evidence. 3, held in contempt or otherwise sanctioned, or both, for trial misconduct, including in his closing arguments. The court incorporates by reference the attached October 2nd, 2025 declaration of Mr. Anderson and exhibits and affidavits. It is further ordered that, but wait, there's more. This order to show cause, together with the application and memorandum of points and authorities and declaration of Mr. Anderson, shall be served on Ron by personal service or by some yahoo.com email address that has nothing to do with his name or the name of his law firm. I don't even know. No later than November 4th, 2025 at 5 p.m. Proof of such service be filed at least 26 days prior to the hearing. You need to serve this to make sure Ron has it in his hot little hands by November 4th. Personal service and email. He needs to be served because he is pending contempt and contempt sanctions. Hey Leonard, a brief word from our sponsor today, Jones Road. You guys have been asking me on stream about what I've been using for makeup, and one of the things I have been loving lately is the Jones Road Miracle Balm. I'm also super partial to makeup that multitasks, has skincare ingredients, and I can use with my fingers. I know it sounds like a lot of things, which is why you're gonna love Jones Road, because it is a minimalist makeup brand founded by makeup artist Bobbi Brown that creates versatile, easy to use products that simplify your routine. And unlike other makeup products, it's not sticky, it doesn't slip into my pores or fine lines, and it really is a multitasker. You can use it as a tint, a blush, a bronzer, highlighter on the lips, however you want. And because we are getting into holiday season, if you're ready to simplify your routine with makeup that's clean, strategic, and multifunctional, you definitely don't want to miss out on their limited edition holiday sets. They won't be here for long, and once they're gone, they're gone. They launch on November 6th, and just for you get a free cool gloss when you use code LAWNERD at checkout. So head to jonesroadbeauty.com, pick up your simple multifunctional makeup and your free lip gloss with code LAWNERD at checkout. Head to jonesroadbeauty.com and use code LAWNERD at checkout. And if they ask how you found them, let them know it was from the case briefs. Now let's get back to it. So then Ron responds, Emily, what response is needed? None to this. Emily, what is the proper response to this? Show up to the hearing. Emily, you read in the last filing that Ron said he had hired a lawyer, so he was not going to respond further because he needed his lawyer to respond. Yes, law nerds, all of those things are true. And yet, here we are, electronically filed 10/27/2025 at 12 a.m. on the dot. Objection and response to issuance of order to show cause regarding Ron's trial misconduct. He is responding to the judge saying, hey, Your Honor, I object to your ruling. I object to your order. Stop it. To the honorable court and all parties and their attorneys, defendant Cardi B obtained a defense verdict against plaintiff on September 2nd, 2025. Defendant made specific statements on September 2nd to all of the news stations that the parties would be walking their separate ways when she left the Alhambra courthouse. You already said that. It also isn't relevant. Also, what the fuck does that have to do with your OSC? Cardi B's not asking for the OSC. Her lawyers are. What is this world coming to if you can't trust that in a press conference when she was clearly talking about someone else and I interpret it to be about me because that serves my purposes the best, I can't rely on that. We watched that the last time we covered this. He has not moved on. I feel like the copy paste is strong. Plaintiff agreed to move on with the understanding that the entire case would be put to bed. There's no agreement to be had. You lost. The issuance of an OSC retrial misconduct against plaintiff's counsel is extreme and inefficient. Contempt would require plaintiff's counsel's conduct to be willful, which it was not. Trust me, bro. Plaintiff's counsel is not a quote, and yes, he put this in quotes for those listening in the background. He is not a quote, seasoned trial attorney and did not intentionally attempt to violate any court orders. He didn't intentionally attempt to violate it. He just did it. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial. Plaintiff's counsel was simply asking questions as best he could in an effort to zealously advocate for plaintiff. Plaintiff's counsel did not ask questions in attempt to willfully violate any court orders, but you did violate the court orders. There are rules on what questions you can ask, and you have to follow those rules. Defense counsel goes on in an effort to paint a false picture of plaintiff's counsel by presenting a total of 25 counts. Count 1, plaintiff's counsel asked one question about current, it's my italics voice, current gang affiliation. This line of questioning was drafted by plaintiff's counsel's office manager and asked in error. You're throwing your office manager under the bus. Also, office managers, from my understanding, manage appointments, emails, billing, gathering documents, but they are not part of the legal team in that way. Office managers are great, but they're not part of the legal team. Why are you throwing your office manager under the bus in a filing? Also, it's your responsibility to know what the orders are, not your manager's. Also, why aren't you prepping for trial yourself? Also, you can't just rename ChatGPT to office manager and say it's your office manager. Also, you have to know what the motions in limine say when you are drafting your question. Are you letting non-lawyers do legal work? Also, Do your clients know that your office manager is writing the work that they've paid you to do? Different than a paralegal. But if this was a paralegal, I imagine that he doesn't have a paralegal because they would be like immediately no. But if you had a paralegal, they would have known what the motions in limine were. But I can't imagine a paralegal hanging around for this shit. This is not a clerical or administrative error. This is not a miscalendaring issue. Miscalendaring issues happen. Clerical errors happen. My office manager drafted the line of questioning. Cardi B is the person you are suing, and you weren't drafting the questions of the defendant who you didn't depose. These are the main questions of the main witness. He goes on to say, plaintiff's counsel made a rookie mistake to ask this question. It was not asked to willfully violate any court orders. He didn't know what the court order was, is the thing, because he argued that this didn't violate the court order. His first argument was, excuse me, Your Honor, your order said past gang affiliation. I asked about current gang affiliation. And the judge dead ass said, nope. Read the order again. So his first argument was, I knew the order, I interpreted the order, and this is a gray zone in the order that I intentionally exploited. And now it's my office manager wrote the question. It was a rookie mistake to ask this question. Count two. There were so many trial documents being exchanged that this must have been filed in error. Plaintiff's counsel did not willfully attempt to present an improper joint witness list to the court. Counts 3 through 9. Defense counsel makes incorrect allegations about questions related to Dr. Avila. Plaintiff's counsel asked questions about Dr. Avila on the first day of trial on August 25th, which were overruled by this honorable court, see Exhibit 1. There did not appear to be an issue with asking questions or discussing anything related to Dr. Avila when the court overruled the objections on the first day of trial. But Your Honor, you allowed it once, it's fine. Count 10 through 25. Plaintiff's counsel presented a closing argument as best he could. This was a televised case with high emotions and very little sleep. All trials have very little sleep. I mean, nobody said this was a healthy profession with boundaries, especially when you're a litigator. Defense counsel argues that plaintiff's counsel's closing argument was presented in an effort to willfully present facts outside the evidence. You did that. You presented facts outside the evidence. Plaintiff's counsel did not willfully intend to present any facts outside the evidence. Any such statements were errors. It is evident that defense counsel, Mr. Anderson, has something personal against plaintiff's counsel. This is Ron talking about himself as plaintiff's counsel. Plaintiff's counsel has lots of respect for this honorable court and has expressed that in this case and other cases. Plaintiff's counsel took this case on from another law firm for the sole reason of giving the plaintiff an opportunity to be heard. Not every case goes to trial. And I have to imagine that the other law firm looked at the plaintiff and said, you are not going to recover in this case. This is not winnable. I am sorry that this happened to you, but you cannot go to trial on this. You cannot go to court on this, and we will not file this lawsuit. And Ron said, I will. Plaintiff's counsel has already lost thousands of dollars in that pursuit, even though he is struggling financially. It sounds like decisions have consequences. It continues. Preparing a formal opposition to an OSC will require plaintiff's counsel to spend thousands of dollars, which he cannot afford at this time. Numerous hours will also need to be invested fighting this on a case that should be over. The Honorable Judge Fusselman presided over this entire trial. It would appear that this honorable court would not find plaintiff's counsel to be in willful violation. In what fucking world? The judge was going to order an OSC even if the other side didn't. He said it directly in court. This case is giving plaintiff's counsel a significant amount of anxiety. Your Honor, my anxiety. You have shown that you are willing to try to win at all costs and violate the court orders. In another case, you were called a menace in the hallways. Do your job. Plaintiff's counsel respectfully asked this court to give plaintiff's counsel the benefit of the doubt. Plaintiff lost the case and there was no prejudice to defendant. This is not a no harm, no foul situation. This is a pattern of conduct. Also, you have wasted, at least in another case, significant judicial resources and time by burning a jury that had been in trial for multiple weeks on a malpractice case, a case that is going to resume trial soon. You can't just stomp your foot and then say, but Your Honor, this is too stressful for me. There shouldn't be consequences. You chose this case. You chose this profession. No one has done this to you. And this motion reads like a 3 a.m. Reddit thread of grievances. Taking cases to trial is rare and requires attorneys to be willing to do so without the fear of reprimand. Clients have the right to counsel. Counsel has the right to take unpopular clients, but you have to follow the court orders. This is not that. Also, it's Los Angeles. Things do go to trial. Plaintiff's counsel will be taking a trial advocacy class to better understand how to proceed to trial. It's the willful violation of court orders that are the problem. You went to law school. You passed the bar. I feel like after practicing for 20 years, you know, and that these tactics have worked and there have not been significant enough consequences. Plaintiff's counsel is willing to provide this honorable court with proof of completion if that will satisfy the court. The court's going to hold you in contempt. Also, I would love to hear the conversation about when you go back to your law school and say, hey, I need to take a trial advocacy class because I'm trying to not get in trouble with the state bar. They're going to say, please don't tell people you went here. It says plaintiff's counsel is already going to be judged by the state bar of California. In this case or in others, I have questions. Plaintiff counsel requests that this honorable court not issue an order to show cause regarding trial misconduct in the spirit of compromise and efficiency. I don't think I've ever seen this much gaslighting in one filing. Plaintiff's counsel is limited in his ability to provide additional information at this time as he is represented by counsel. Does counsel know that? Because no one's filed an appearance in this case. For this reason and the additional reasons set forth, it is requested that this court not set an order to show cause hearing related to plaintiff's counsel. The hearing's already set. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial. Trying to throw a temper tantrum rapid fire at the court is not going to change the fact that the court made orders in the motions in limine and you did not follow those orders. Exhibit 2, email from Cardi B's attorney to plaintiff's attorney, Ron, on August 4th. Dear Mr. Ron, I am writing in response to a voicemail message you left for me at 8:47 a.m. today. First, as a general matter, I reiterate that as stated in my August 2nd letter to you, and for the reasons stated in that letter, bold, all communications between our office must be in writing. Do not attempt to call me or any of my colleagues, and instead confine your communications to email. Second, I write specifically with respect to one aspect of your voicemail message this morning, namely your threat to hold a press conference about this lawsuit and upcoming trial. Why did Ron include this email? Oh, Ron included this email to tell the court that Mr. Anderson was threatening him. That's why he included this email. California Rule of Professional Responsibility 3.6 bars lawyers from making extrajudicial statements that the lawyer knows or reasonably should know will be dismissed by means of public communications with a substantial likelihood of materially prejudicing a jury pool and jury trial. Obviously, your threat to call a press conference about this case a week or less before trial is within that rule and prohibited. Since you also state that you have received inquiries from the press, I note the same prohibition applies to you talking to the press. We reserve all rights, claims, and remedies, also including defamation, as to any statements you may make to the press or others, and the right to advise the court of your threatened press conference. Where in this letter does Mr. Anderson threaten Ron? I'm missing it because I feel like this email is just a bro. You said you're going to hold a press conference. Remember, you can't do that. I can't even wrap my head around the fact that these are real filings in a real case, because it feels like TV show parody of bad lawyering. But I think in the writer's room, they would say this jumps the shark. It's not even believable. It's absolutely staggering that this is continuing with the foot stomping. The judge has to be absolutely baffled at this response. And the response is also, but also I can't respond. Your Honor, don't hold this hearing. I can't respond. But also, he threatened me. He's obsessed with me. He's mad at me. I don't even know how you respond to this. He's just throwing all of the excuses at the wall. None of those, by the way, are explanations for the contempt. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.